And that concludes my remarks for this morning. Good morning, everybody. Good morning. I'm going to talk about a few things. I've passed out an outline. There's a number of items in there, and if none of those items are suitable, we can always play Stump the Attorney, in which you ask me impossible questions and I make up answers. I'm going to talk about a few things. The first thing on the outline is called neighbor to neighbor, and what that really means is neighbor disputes over property lines and trees and similar kinds of things. Very common. Certain areas are worse than others, that based upon how areas were divided up, whether the engineer who divided up an area was paying attention. There's some areas where that didn't happen. I won't mention any in particular, but some geographic areas are much more common to have problems of exactly where the lot line is. So I'm going to talk a little bit about that, and it does tie into the next item and then one after that, which is preliminary reports and avoiding negligent misrepresentation. Because this whole subject is, what's the condition of the property, what are the dimensions of the property, where's the lot line, am I going to have a similar kind of a view? Boy, this is a terrific view. Is the neighboring property going to be able to be built on, or do I get to continue having this view? It's a big factor in how people decide to buy properties. So what I want to focus on is the importance of not knowing every piece of information in the universe. No one can know everything. To have a property, and you have a client, you're showing a property to a client, and the client says, well, where is the property line? Is the fence line the true end of my ownership, or that block wall, or where the old tree used to be? The answer really is what?
I don't know.
I don't know. Thank you. I don't know is not a bad thing. It's something we all don't want to do, because we all feel like we're supposed to know things and be able to guide clients. You can guide clients. There is a great way that you can guide clients, give them correct advice, perfectly correct advice. And the answer on lot line and dimensions and buildability of neighboring parcels and things like that is kind of the same thing. That is, get someone into the discussion who is an expert in that subject. The lot line questions, experts would be surveyors, civil engineers, but guess what? Who you have already got into the transaction, once you have a preliminary report, is a title officer. In the preliminary title report that you get, or preliminary report, there's a name of a live title officer right on that report. Not a title rep, a title officer. That is the person on whose desk the buck stops. That's the person who can tell you whether there are restrictions on neighboring properties against height, against the ability of a neighboring property, for example, to build beyond 1 story or 2 story or whatever issue you're dealing with, or precisely where the property line is, or what other restrictions on use are recorded against the property. When you look at the prelim that you get in every transaction, the prelim is really like going into a restaurant. It is not all the information. It's really a list of documents that have ever been recorded since the recording system began to the present. And so you can't say, it's like going into Denny's and say, well, gee, what is that particular sandwich going to be like? You can't tell that from a menu. You can see a basic summary of what the sandwich is supposed to be like, but how it is going to taste and exactly what's going to be on it, you're going to get when you get the sandwich. Same way in a prelim. It'll say CC&Rs recorded January 9, 1962, document number so-and-so. It might be CC&Rs for a homeowners association, or CC&Rs for in connection with a lot division of some sort. You can't tell what those are, what those restrictions are, without actually looking at the document. I'm not suggesting that you get the underlying documents on every transaction. It's not something that real estate agents and brokers typically do. And once you start down that path, you've gone to a place you don't really necessarily want to be, of interpreting legal documents. The best thing is to find your client a suitable expert, which you can do, and get that client to ask the questions of that person. Title officer is that person. In my experience, if you can get a hold of some kind of an expert, say in title or some other aspect of a transaction, most of the time people are happy to share their expertise. They go home, they get up in the morning, they go to sleep at night, knowing more stuff than their significant other wants to hear about, or their friends, or understands. So the best favor you can do your client is to get someone else involved in the discussion. They can ask all those questions that they want. The avoiding negligent misrepresentation side of it is this, that among the kinds of claims there are when someone files a lawsuit or an arbitration is negligent misrepresentation. That is a claim where you're saying that I'm making a claim against you, I'm suing you because you told me something that turned out not to be true. Now, maybe you didn't think it was untrue, maybe you believed it was true, but you didn't have a sufficient reason to think it was true. Whether that is the property line is over there 3 feet to the right, which turns out not to be correct, you believed it, but you didn't have it on the authority of some kind of an expert, you just believed it for some other reason, or the seller says, when you ask a question, how old is the roof? And the seller says, well, the roof is 3 years old. I had the property re-roofed. So if the buyer says, well, how old is the roof? What's the right answer? The answer is according to seller, or seller says the roof is 3 years old, but what? What do you follow that up with? I have not checked that. You should do that in the course of your due diligence. Because now you have made a perfectly accurate statement, as opposed to saying the roof is 3 years old. So a negligent misrepresentation claim is a claim where someone says, well, again, where someone says you gave them information, you may have believed it was true, you didn't have a sufficient factual basis to think it was true, they relied on it, it wasn't true. The roof is really 13 years old in most of the places. Maybe the seller had a little bit of the roof redone 3 years ago. So it's really a matter of citing source and not going beyond what you actually know. Then you made a perfectly accurate statement. California case law, there's a case called Robinson versus Grossman, in which a realtor was asked what the cause was of some cracking in plaster, I think, on the exterior of a building. And the agent said, I don't know what the cause is. You should check that out. I'm not going to be checking that out. So they went forward with the transaction, closed, and the buyer was unhappy with what it turned out to be the cause of the problem and what it was going to take to fix it and the extent of it, and sued. So what do you suppose happened in that case? Guess what? Is everybody sitting down? The broker won in the Court of Appeal because he did exactly the right thing. He said, there's cracking in this area of the plaster. I don't know what the source is. I don't know. I'm not going to check it out. You should. So when you are filling out disclosure documents, this same issue applies. Now, my rule on completing disclosure documents is use nouns, not adjectives. So what does that mean? Is this Steve Sokol's grammar exercise? No. This is when you fill out a transfer disclosure statement or an AVID or some other kind of a disclosure doc based on an inspection or based on anything. Sometimes you see in an agent's portion minor cracking in driveway due to normal settling. So what's wrong with that statement?
All of it.
All of it? Well, what is okay in that statement? Minor cracking in driveway due to ordinary settling.
Minor cracks.
Well, I wouldn't even use minor. Minor is an adjective. The only reason you're putting the word minor in there is to say, now, alert, I'm about to tell you something that sort of sounds significant, cracking, but because I'm using the word minor, that means don't really pay attention to this. It's not significant. You don't want to be saying to a client, a customer, what is significant and what's not significant if you don't really know what the extent of the problem is and what the source of the problem is. So you don't really know that it's due to ordinary settling. It could be that the sewer pipe has washed away so much dirt from underneath the driveway that there's now a cavern, and that's why the driveway is cracking. Could be. Or it could be any number of other things. But what's clear is that you don't know what the nature, what the source of the problem is, and there's no reason to go there. How many of you have ever had a sale cancel because you said cracking in the driveway? And one hand up. And would the sale have not canceled if you had said minor cracking?
I just said, no, I said, I showed what the cracks were. I said, here, please pay attention to this and do your own due diligence, whatever it may be. The seller has put some, sealed it, but it's up to you to go from
Right.
there.
The key is bring the item to the attention of the client or customer. Don't cite a source because you don't necessarily know a source. And the buyer or client, customer, lessee, whatever the nature of the client is, can make whatever choice they want to make. So that's my strong advice. Another bad thing to be putting into transfer disclosure statement in the agent portion would be terrific property, real opportunity, mini estate. That's not the moment for advertising. That's the moment for saying, here are some facts that I am aware of that I've discovered in the course of my diligent visual inspection of the property that you, buyer, may want to be aware of. And if you can't find anything at all in the property that is worthy of disclosure, then you need to look again, because every property has got something. There's no such thing as perfect, except my children. And they're not here, and they don't fill out transfer disclosure statements. So what you need to generally do is find something. There's always going to be something, that a mismatched something or a scratched surface on a different component of the property, because the object of that is to say, I really did do a careful visual inspection of accessible areas, and I did disclose to you defects that came to my attention. The level of skill that you're required to bring to the table when you do a transaction is the level of knowledge and education and experience necessary to get a real estate license. You don't need to be a reasonable civil engineer or a reasonable astrophysicist or something else. There are people that do those kinds of things. There are specialty inspectors, obviously, electrical, plumbing, roof. You need to be a reasonable real estate agent, do a careful visual inspection of accessible areas, and disclose what the results are of that inspection. Your life will be better. Trust me on this.
I have a question. What about the flip side? If you said it's in generally poor condition, rather than building up the property, what if you were building it down? Would that be okay?
So the question is, what if you say in there a general comment that property is in generally poor condition?
There's so much to go.
You can say that. I mean, you need to be careful that you're not. Depends on what you say. How bad a comment you make. It needs to be factually accurate or based on your opinion of what it is. You still have to go through. I mean, there's no safe harbor on exactly what's enough to say. So if you're required to go through the property and say there's cracking, if you note a significant item, you're required to say that item. And you can't. The disclosures in the transfer disclosure statement and the AVIT are really not waivable. So you just have to think in terms of saying enough, that it's clear that you did the right thing and that you can prove you did the right thing by putting what your observations were into writing. Marilyn Barnett.
Sokol. Your copy's here, by the way.
Thank you very much.
So what if a seller hands you a list of Put the seller hands you a list of things that they think should go onto the TDS, a real left-brain type person. And some of them you might think would not be necessary. Would you just attach the list and not say anything, and that's just it?
If the seller gives you a list of items,
They fill the TDS out. plus
and then they hand you another item, and they're either an engineer or a pipe smoker, so they have a long list of things.
You know the person.
Yes, I've met that person, yeah. So you really don't want to be in a position of saying that you don't need to disclose this item or that item unless it's categorically clear that there's no way that that you should be disclosing it. If the client says, should I, do I need to disclose the fact that someone died in the property 5 years ago? My cousin, died under the following circumstances. Well, the answer is, of course, there's a statute that says in effect, it says you have to disclose death up to 3 years ago. It doesn't exactly say that, but it says you can't be sued for failing to disclose that a death occurred more than 3 years ago. But having said that, if you have knowledge of something, then the better answer is disclose it and let the buyer make their mind up of whether it's going to be significant. Once the seller tells you something, unless it's just completely, call your company attorney, call the CAR legal hotline, and get someone to say, well, yeah, that is not a legally required item, then maybe don't disclose it. Otherwise, I would err on the side of giving the disclosure. Most things, on death, even a death, let's say 3.5 years ago on the property, that you know about and you don't disclose, guess what? Within about 48 hours of when buyer takes possession, they're going to know from the neighbor or from the welcome wagon people that bring over the fruit basket, congratulations on moving into our neighborhood, it's wonderful. You do know about the death on the property, don't you? So it's not just the issue that you have an issue of death, whether you disclose. It's that it starts to turn the buyer against you generally, or can, so that the buyer, if they have some other little minor problem, then they're going to be more likely to say, this is your fault, you should have told me this, I have been damaged as a result. So if you ask a lawyer a question of do I need to disclose it, nearly all the time it's going to be yes, in a residential sale. It's hard not to get there. Brief item on titling for couples. We have a lot more couple choices than we did say 20 years ago in California, obviously. So we have community property, and we have community property with right of survivorship. And I'm going to mention these issues for background information. This is certainly not something you should be making choices for your clients. This is estate planning and financial planning and has legal implications for your clients. But as an issue of background for your client, in dealing with your clients, community property means property that was acquired using funds of a married person that were earned while the person was married to this spouse. So a married couple, one works, the other does not, or they both work. There's a bank account that contains earnings from either of them, and that's used to buy a piece of property. The property is going to, in the end, be community property, whether they call it community property or not. So where this comes up is frequently toward the close of escrow, when you are filling out, you're having your client fill out the information statement that the title company requires. That's used by the title company to determine whether there are liens against the buyer or seller, whether there are bankruptcies, whether there's been a divorce, and whether some other individual who's a spouse or former spouse is going to have to sign off on a document. Spouse now means, in California, could be opposite-sex couples, it could be same-sex couples, because obviously we have same-sex couples as a result of court appellate decisions. That fact does not eliminate registered domestic partnerships. So we have had registered domestic partnerships in California for many years, many, many years. And anyone who was a registered domestic partner still is. The fact that marriage between same-gender couples is legal does not change the status of anybody who's already a registered domestic partnership. And in fact, you can still become a registered domestic partnership. It's a different process of becoming a domestic partnership. It's a different process of dissolving that than compared to a marriage. Because dissolving a marriage requires a court proceeding, a dissolution of marriage proceeding. Dissolving a domestic partnership is not that way at all. Either way, domestic partners are, for every legal purpose, have all the same rights to each other and responsibilities to each other as married persons. So if you have a domestic partnership, one works, the other does not, or some combination, earnings of either domestic partner are the community property of both of them, whether they are same-sex domestic partners or opposite-sex domestic partners. Domestic partners can be two different kinds of people. One is two people who are at least 18 years old of the same gender. Those people can be domestic partners registered in California. The other are opposite-sex couples if one of them qualifies for Social Security benefits. So you can't have a 25-year-old, say, couple that are one female, one male, be a registered domestic partnership that registers in California. That you can't be. You can be opposite sex if one qualifies for a Social Security benefits. And if you wonder why that is, and I'm glad you asked that question.
Why is that?
Thank you for asking that question. The reason for that is that California enacted this many years ago because if one of them is on Social Security survivors benefits, widowers or widows survivor benefits, because a prior spouse has died, well, the moment that that person gets remarried, they are cut off permanently for the rest of their life from survivor benefits from that particular marriage. So if you get remarried, you're cutting off your Social Security benefits, not usually what people have in mind. So the sort of marriage light method of both feeling like you're committed to each other in a meaningful way, but also not keeping your powder dry in case something goes wrong, would be the basis for why people, opposite-sex couples, sometimes use domestic partnership. It's not just if the second relationship, the domestic partnership, doesn't work out. Even if it does work out, you would still continue to be able to draw the survivor benefits if you are domestic partners. Ma'am.
When you mean domestic partners, let's say they're living together, right? But they're not married, they own a property, would it be right that also, I mean, I know I'm not supposed to advise them, but I'm just saying that could it be community property with right of survivorship? Or does it have to have contact, like meaning marriage, for them to be able to have that right of survivorship? Like domestic opposite sex, right? Not married,
Right.
but acquiring the property, community property with right of survivorship, but no marriage. How does that
Then the-
play?
Okay, then those are, the easy way to analyze that is take away the question of whether they're married versus they're registered domestic partners. If they're registered domestic partners with each other or they are married to each other, then the earnings of either one of them are community property, unless they have a prenuptial agreement, a formal prenuptial agreement that says my earnings during this marriage or this domestic partnership are mine, yours are yours, and lays out a different mechanism. If they do not have a proper prenuptial agreement, then whether they're domestic partnership or they're a married couple, all of their earnings and anything you buy with the earnings and anything you trade other community property to get is community property. They don't need an agreement in order for that to be the case. They would need an agreement, proper agreement, in order for that to not be true. So if you are domestic partnership or you are a married couple, you can hold title as community property, old-fashioned community property with right of survivorship, or joint tenancy. Joint tenancy is the one that most people end up with because that's what the advice that they get by calling the 1-900 number of the Psychic Friends Network tells them that must be what I should do today. Because that's been around for a long time. Joint tenancy, the answer for why most people pick joint tenancy is, well, that way we avoid probate and there's automatic survivorship, sort of, to the survivor. That's true. But it's also true that if you have community property, community property with right of survivorship, it's automatic survivorship to the survivor. The problem with old-fashioned community property was that if it's just plain community property and one spouse or one domestic partner leaves a will leaving his half or her half of the property to their aerobics instructor, let's say, and then that person dies and the surviving domestic partner is grieving for the loss of his or her life soulmate, and then on the door there's a knock, and the aerobics instructor of the deceased domestic partner says, "Hi, I'm a half owner of the property." If you think about it, that could be the finest gift that the deceased partner could make to the survivor, because all of a sudden the survivor who's going through terrible grief at losing their soulmate will get over that feeling very quickly, and now
Get a different one, but
so that is it happens. That actually happens. So that's because it's community property, plain old community property. So joint tenancy does not have that problem, but joint tenancy has a tax issue attached to it. Joint tenancy, even if one of the spouse or domestic partner who dies leaves a will leaving their portion of the joint tenancy property to someone else, that will not have any effect. If it was joint tenancy at the time that the person died, then the other joint tenant will own the property upon the death of the first one. Or it could be more than one individual. It has to be individuals that can't be legal entities that are joint tenants. So to get past that problem, the problem of the one spouse or domestic partner or co-tenant leaving it secretly to someone else, the California legislature enacted community property with right of survivorship. Community property with right of survivorship means that it's community property for the tax reasons that make community property beneficial, but it is survivorship to the other, to the surviving spouse or domestic partner, regardless of whether the dead spouse left a will leaving it to somebody else. So a will would have no effect on community property with right of survivorship. So depending, again, I don't want to say how your client should choose to take title, because that's an individual choice. It depends on their precise circumstances. They need to get legal advice, from whatever source they choose to do that. If they have a client that gets his advice from his barber, well, that's fine, as long as